It's my pleasure to call Professor Niva Elkin-Koren, Professor of Law at the Tel Aviv University. Niva.
I'll just say it's a pleasure to be here. I'm a law professor at Tel Aviv University, and I've been studying content moderation and online speech for over 2 decades. And I guess I'd like to say a few words just before we start about, that would help us zoom out from the Israeli case to look at disinformation as a general challenge and problem for those of us who care about the regulation of the internet. And so the first point is that disinformation is not about the information itself, but rather about the threats of attacks that could destabilize democracy. And again, this is a problem that was identified by the Global Economic Forum as a strategic problem for liberal democracies. And obviously, since we're talking about democracy, that would trigger some trade-offs. So this is a second point, that this cannot be aggressive defense against disinformation. It will always tackle some trade-offs between the need to protect the safety and security and stability of democracies on the one hand, and values such as privacy and free speech on the other hand. The third point that relates to my talk is that we have different tools. So one has to do with what Gili was mentioning in her opening remarks, and that is technical tools. And we actually were running in collaboration with the Cyber Center here at Tel Aviv University and some other partners, together with the Shamgar Center for Digital Law and Innovation, a competition for developing tools that could actually tackle disinformation. And enough was said about the competition. But in my talk today, I'd like to talk about the way in which regulation can also be a tool, and to ask the question of whether platform regulation, the one that was actually mentioned also by Cedric, can actually be effective in addressing some of the disinformation challenges. And for that, we have to go back to platform regulation that was actually, we have to go back to the 90s, where platform regulation actually was put in place that basically took the stand of a hands-off of the internet, sort of saying intermediaries are intermediating content that is posted by users, and we're not going to hold them responsible for that content. And that is the basic regulation in the United States that is really significant, because most of the intermediaries that are now intermediating our content and exchanges online are American companies. And so Section 230 that provided full immunity except for a few exceptions. And then in the European Union, also the idea that platforms or intermediaries, including internet service providers, but later on social media platforms, have to do nothing unless they're being notified. And this type of regulation had basic assumptions. So the one assumption, the main assumption, was that if we keep the intermediaries immune, we can guarantee the freedom of users, because intermediaries will not engage in content moderation, will not decide what content is on or off, and therefore that would be sufficient in order to secure freedom of expression of all of us that want to use this service. The main purpose of the safe harbor environment, regulatory environment, was to create dispute resolution system that would enable people to complain and then require some of these intermediary social media platforms to actually remove some harmful content. And then the third part of this regulatory framework, generally speaking, was about the content itself. So it was about particular instances of posting infringing materials, inciting materials, disinformation or misinformation. Moving forward to 2024, we see that some of these assumptions that were leading this type of regulation are no longer valid. And so, first of all, the intermediaries that have, the big platforms that are now running our digital public sphere are engaging in content moderation, and their business model, it depends on engagement of users with content moderation. They actually control not only access to information, but also the type of information that can go in or out, and the type of information to which we are exposed through the recommendation systems, through the monetizing or demonetizing of some of the content, and the type of virality that we allow or do not allow. And so these intermediaries these social platforms have a lot of control over what is on or off these spheres. Gen AI was mentioned here before. I'm actually less concerned of deep fake. I think that this is a matter of education and social orientations. People were really, really afraid of cinema in the last century, and they thought people will not be able to differentiate between what is on in film and what is off. But I think that with Gen AI, we will develop tools both for people to be able to cognitively differentiate and also for us technologically to be able to technically detect what has been produced through measures of provenance that will be able to mark these. But what is really important is that Gen AI actually creates a threat because it actually enlarges the scale of what could be distributed, because each of us can actually generate these type of disinformation that could be convincing quickly at a large scale. Last point is that what we are seeing in the context of disinformation are not particular content that is true or false, but campaigns, strategic campaigns. Beyond these technical changes, what we also have is emerging over the past 20 years is deep ideological divide of what constitutes free speech. We disagree on that. We disagree on what free speech we need. And so you have the libertarian views, some of whom are actually controlling some major social media platforms that actually believe that everything should go, that free speech means freedom of government involvement. And that is the approach that has been taken by Twitter. But on the progressive side, you see people that are actually concerned about free speech as an environment that would enable more speech or will be protected from hateful speech that would exclude some marginal groups. And so we are divided as society as to how much do we want disinformation, what do we consider disinformation, and what type of free speech do we want, and whether platforms are actually removing too much or too little. This is a critical point, and the reason is that as lawyers, we often think that it's sufficient to decide what free speech, that we should secure free speech, and then we let judges and regulators down the road to negotiate the meaning of that. But when we build systems that are filtering disinformation, we have to decide up front what we think is disinformation. And therefore, if we disagree, that creates a social and political challenge. And so what we are seeing in 2024 is actually a huge change in this environment that I've described to you from a regulatory point of view. And so in the United States, you see, for instance, initiatives, legislation in Florida and Texas that are actually shifting from Section 230 to a different type of approach to online social media that is a must carry. You cannot remove, right? According to your discretion. You have to carry whatever content is out there, except for very, very extreme cases. This is actually under review of the Supreme Court this summer. We have some reforms to change Section 230. And of course, we have some thought, reconsideration in the United States about freedom of speech that is also going to be challenged in the United States Supreme Court related to the TikTok ban. In Europe, we have a lot of legislation, and actually I'd like to say a few words about this digital strategy because it's relevant to our discussion here. The digital strategy or the Digital Service Act cannot be understood as a standalone. It is part of an ecosystem of regulation that is connected to the GDPR that protect personal rights in personal data. It is related to Digital Market Act that actually applies some restrictions on the way in which platforms can actually exercise their market power. And in particular, the Digital Service Act is an act that actually differentiates between mice and elephants, right? And so most of the focus of the Digital Service Act is on the elephants, on the social media platforms. And Cedric was mentioning before, illegal content is something that we can all agree upon, right? Because there is a government, there is law. If the law provides that something is illegal, then we can require a platform to remove it. Also, there could be some accountability related to what platforms have promised to remove according to the terms of service. And on that, we can all agree as well. The issue is the harmful content, and that is where disinformation, that is a fuzzy word, is not defined. It relates to the circumstances. It depends on the point of view. That is where the DSA is actually providing some vision. And the vision of the DSA is a shift from looking at a particular content into perceiving this problem of disinformation, but harmful content in general, as a strategic problem, as a systemic problem. And so very large platforms are required to run a risk assessment. They also required to undertake risk mitigation measures. And they also have to engage some independent audits. So it's not just self-regulation that is up to them. And so I think this shift from the micro approach, looking at content, into a systemic approach, and from a reactive approach that is, let's wait that someone is notifying me, into a proactive approach, this is where there are some lessons that could be drawn for other countries. One challenge, and this I will conclude soon, that remain unsolved in the European approach, and I think that we should all be aware and cautious about this, is a way in which this approach is still is too much reliant on the regulatory power of the state. We normally think of citizens as being protected against the state by our constitutional rights, against commercial companies by our consumer rights. But what if the platforms and the governments are working together? When the government is using platforms in order to protect citizens from disinformation, that should create some concern to us, because who is going to protect us against this converged power? And the problem is that in the case of disinformation in particular, what we see is that the campaigns of disinformation are not only external, therefore requiring protection against some foreign attackers, but also internal, and sometimes combined, and in a way, and converge in a way that is very difficult to differentiate. And so in this context, what we really need to think about is more of policy intervention that are multiple. To look at platforms as a feature, we can discuss more of that, how to take advantage of their incentives to actually mobilize and work with governments around the world. That is a feature for liberal democracy that can protect their citizens from their own government. We should use regulation for incentives. We should use litigation by civil society. And we also should rely on self-regulation in order to create some certainty in this environment. Thank you.